Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. This week on The Lawyer You Know, we're unpacking the facts and breaking down the Ronnie O'Neal murder trial, which is happening right now in Tampa Bay. A few years back, Ronnie O'Neal was accused of killing his girlfriend and the mother of his children by blunt force trauma and gunshot. He was accused of murdering his special needs daughter with an axe and stabbing multiple times his son, as well as lighting him on fire before he somehow escaped and is expected to be the prosecution's main witness. This is as sad of a story as you can find. But there are a bunch of interesting legal issues going on in this case before the trial even started, and then now that the trial has begun this week. Back in 2018, when this happened, there were all sorts of, statements made by the defendant, such as screaming Allah Akbar over and over again, screaming about white demons, screaming about how a white demon tried to kill him, but he actually killed the white demon. All sorts of statements that would make you think this is going to be an insanity plea. And to take that a step further, Ronnie O'Neal was actually found to be incompetent back in 2018 when this happened, which means he doesn't have the mental fortitude to understand the process going on around him, to aid in his defense, to understand the charges being levied against him or the potential penalties. Is he still incompetent? Are they going for an insanity defense? Not only is he found to be competent now, and not only are they not arguing an insanity defense, he is actually representing himself pro se. He is acting as his own lawyer. And today we're going to break down his opening statement. We're going to talk about what the differences are when somebody represents themselves versus having a professional lawyer give an opening statement. We'll talk about how the rules are kind of different. We'll talk about how the judge treats them differently. When I was a prosecutor, I tried a case against a pro se defendant, and really it was miserable. It's so hard because the rules change. We give them so much more leeway because we don't want to create an appellate issue. We don't want to create a technicality that gets them off. So we let them do things that lawyers are not allowed to do, that the rules of evidence do not allow us to do in trial. And you'll see a lot of that in his opening statement. Abraham Lincoln, some of you may know him, had a famous quote: "A man who represents himself has a fool as a client." Okay, which is just basically a warning against representing yourself, even if you are a lawyer, but definitely if you're not. I mean, there are things that lawyers know how to do in the process that they understand that gives you the best chance to be successful no matter what your claim is, whether it's getting you the best deal they possibly can get or trying the case properly. And if you don't know how to navigate these waters, even if you do a really good job, and I'm going to tell you, I'm going to give a little bit of a spoiler alert, right? I've seen a lot of pro se defendants. And like I said, I've gone up against them. We've seen them on TV. We saw Ted Bundy try to represent himself for part of the trial and part of the process. Most of the time, they're terrible. Most of the time, they make no sense. Most of the time, they sound crazy. And while there is some of that in his opening statement, he actually does a pretty good job of picking out some legal arguments, poking holes, understanding reasonable doubt, understanding premeditated first-degree murder. So keep an eye out for those things. And we're going to talk about how he hits some of these technicalities. But you'll see it gets totally lost in the fact that he sounds crazy at times. And he screams throughout this opening statement. So after we break down this opening statement done by Ronnie O'Neal in his own case, let me know if you agree with Abraham Lincoln. Let me know if you think someone who represents themselves as a fool as a client, which means they're a fool since they are the client and the lawyer. Get how that works? Or if you think he actually did a good job and you think that nobody could have explained this better than himself because he was there and he knows things that no lawyer could ever know. So let me know. What do you think? Was it a good idea or a bad idea to represent himself? Please subscribe to our page, like this video if you like this kind of content. We were actually asked to break down this opening statement and talk about this trial by one of our viewers in a comment on another video. So that's what we're doing today. And this is a really interesting case. It's a really sad case, but there's a lot of interesting things going on. And I'll try to point out a lot of them throughout this opening statement so you can understand the process a little bit more. You can understand what it's like to be a pro se defendant, and you can understand what it's like to try a case yourself and how much more difficult it is to try to understand this process when you're not a lawyer. So let's jump into the video. People hate when I talk over the videos, which I understand. But as this camera zooms in on his hand, you can see he's nervous. Okay, he's never done this before, I assume. So it's very nerve-wracking to stand up in front of a jury and give an argument, no less in your own case when your own life is on the line. So let's see how he does.
The evidence is going to show
So if you'll hear, you can hear a difference in the volume happen right there, right? So he starts out screaming, which again, it's really hard not to sound crazy when you're screaming at the top of your lungs, just saying things like the evidence will show. It's really hard not to sound like you're crazy, right? So that's really hard for a pro se defendant, which I understand. They lower the volume, and as you'll hear throughout the rest of the video, the volume sounds so much lower, which is annoying, but they had to do it because he screams constantly throughout his opening statement. And that's one big problem. We would never be allowed to do that as lawyers because it's an opening statement, not an opening argument. I explain this in lots of videos, but in the opening statement, you're only allowed to say what you believe the evidence will show. You will hear him hold on to that tagline throughout this entire opening. The evidence will show, the evidence will show, the evidence will show, which is what a lot of young lawyers do. So that's actually something that I think he does a pretty good job at, is sticking to trying to make it seem like he's just saying what the evidence will show. But the fact that he's screaming and making these arguments throughout is something we'd never be able to do. Let's see if the prosecutor objects to him like they would do to me if I gave this same exact opening statement.
Fabricating fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers in Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred.
We're going to hear what his theories of defense are throughout this opening statement. One of the major ones is that the state, the government, the cops all tampered with this evidence against him, okay? That's fine. You can go with that, especially in today's day and age. People don't necessarily trust everything the cops say and do, so that's one of his theories. But the way he couches it, that the state of Florida, the government, the people here in Tampa Bay are the mass murderers, not him. That's just not an argument that most juries are going to buy, okay? To say they tamper with evidence, sure. If you think you have proof of that, go for it. But he takes it too far, as most pro se defendants do.
And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence.
So, a good legal argument. In criminal cases, criminal defense lawyers all the time talk about the highest burden in the American judicial system is beyond a reasonable doubt. That's the burden the state has to prove in criminal cases. That's how he just made that argument. He said they had such a high burden, they couldn't meet it, so they had to tamper with evidence and create evidence. That's actually a good legal argument. Can't usually say it in opening statements as a private lawyer, but you can as a pro se defendant. That's a good argument. Like, just remember, members of the jury, this is the highest burden in America.
Since it was such evident already, but we still had to tamper with evidence.
You'll also notice throughout this entire opening statement and all the clips that we show, he not only looks ahead of him at the jury, he also looks at the gallery, at the reporters, at the people with cameras, at all the lawyers, at the judge. He's looking at everybody because he's explaining his story to everybody. He's trying to convince everybody in that courtroom that he is not guilty of what they charged him with. That's also a big difference from what private defense lawyers do. We focus on the jury. Once the jury trial starts, they are the only decision makers that matter. They are who we need to convince. They are who we need to explain what happened to. They are who we need to follow our theory of the case. The court of public opinion is over at that point. And the jury is supposed to be there, be isolated, and only look at what we tell them. They're not supposed to go on the news, not supposed to go on social media, not supposed to talk to their friends or family about it. It's supposed to be only what happens in the courtroom. Now, in this day and age, whether or not that's actually what happens, I'm not sure. We've done full reaction videos on how jurors are not necessarily invested on just what's happening in the courtroom. But that's how it's supposed to be. So as lawyers, we just focus on the jury. We're laser focused on the 6, 12, however many people are in that box, that's who we are focused on convincing. He's trying to convince everybody in the courtroom.
The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true.
So as we stated in the beginning, the son is expected to be the prosecution's main witness in this case and most damning witness to Mr. O'Neal. And what does he come out and say? He's already starting to discredit him, and we'll hear more of that near the end of the opening statement. But he's saying, my son's going to say a lot of things that aren't true, and he did not see what he said he saw. Okay? So he's already kind of setting that up, which again is something lawyers do. There's going to be a witness, but he is not telling the truth, and there are reasons why. Okay? He's setting this up. He's hitting witness credibility right in the beginning, which is what lawyers do. I really don't think he does a bad job. I think he may have some issues, and that's why he's screaming and kind of ranting and going on different areas. But I think some of the legal things he points out are actually decent arguments that he's making in this case. As decent as you can when the evidence is pretty damning against you.
The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911. But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society, and I ran after killing Kenyatta Barron knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today.
So this is really interesting to me. He says, I called 911. I knew law enforcement on the way. Why would I run? That makes no sense. And I'm competent. I'm competent. I'm so competent. I'm competent as can be. I'm representing myself today. Okay? So he's using this fact that he is representing himself to show the jury how competent he is, right? Which kills any insanity defense, because we're not going to hear anything about that, even though it may be the strongest defense. But what he doesn't understand is the jury probably doesn't know about any of his competency issues. They don't know he was held to be incompetent. They don't know that a lot of people think he was insane. They're supposed to not know all that stuff when they sit down as jurors, and that stuff's inadmissible. The fact that he used to be incompetent is not something that's going to come out in trial. The prosecution's not going to be able to say, well, in 2018, isn't it true that you weren't competent to stand trial? They're not going to ask him questions like that, but he is now making it an issue. He is now making an argument saying, I'm competent, don't let anybody tell you I'm not. So now can the prosecution bring in evidence to show, actually, you weren't always competent? Because if we open the door to something like that, the prosecution can now bring evidence to show you weren't always competent, especially not back then. Just the differences of when a pro se defendant is making these arguments versus a private lawyer. But he's trying to prove to them he's competent by the fact that he made this decision to represent himself. Abe Lincoln probably would not agree with him.
The evidence is going to show my son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial.
Something we can't do, right? We can't say, there's a witness that's going to say all this good stuff for us, but they're trying to keep him out of this trial. Can't do that. There are all sorts of rules in place, all sorts of things that happen in discovery where you can depose witnesses, find witnesses, serve them, make them show up for the jury trial. So we can't necessarily make that argument, but he can. And again, have you heard a single objection by the prosecuting attorney? Because I haven't. I haven't heard one objection, and that's not abnormal. Usually the judge tells them not to object all the time. That's not the case here, I don't think, because we'll see later what happens when they do object. But a lot of times we don't want to look like a jerk as the prosecutor and as the lawyer on the case. Again, I've been on both sides of this, so I'm trying to explain it from both perspectives. But we don't want to look like a jerk to a pro se defendant. We don't want the jury to be like, oh, they're so mean to this poor guy. I'm not really sure this particular pro se defendant has a lot of sympathy. The one I went up against did, so it was very difficult. We didn't want to seem like the jerks objecting all the time, so that's, I think, why you don't hear an objection, even though this guy just keeps arguing, keeps breaking all the rules of evidence, all the rules that we have to abide by in trial. He's breaking just about every single one of them, and no objections.
Witness me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini strikes on that video and audio that you just heard. And they added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it consecutively over and over like Allahu Akbar, which I may have said once or twice. But they wanted to make me seem like a terrorist. And so you hear it 8 or 9 times, and you hear me calling Kenyatta Barron a bitch and a whore.
So an interesting point by him, right? So he's saying, I may have said Allah Akbar once or twice, but they make it seem like I said it 8 or 9 times, they're tampering with this evidence, right? So he's not just saying they're tampering with the evidence, he's giving the jury a reason why they would tamper with this evidence, to make him seem like he's crazy, to make him seem like he's a terrorist, to make him seem like he's an extremist. So that's why they're trying to do it, because they want to get him for this. They're fabricating evidence to meet that high burden, right? I mean, this guy has got an uphill battle, right? I'm not saying we should, think that he's innocent or anything like that. I'm just saying, looking at him as somebody who's acting as a defense attorney right now, he's making these arguments pretty coherently with a bunch of mumbo jumbo in the background, screaming and saying stuff that doesn't necessarily make sense, but he is making some coherent legal arguments, connecting pieces together to try to give the jury something to hold on to find that the state did not hold their high burden.
The evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile. The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made, because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence.
Okay, so this is a good example here of an argument that so many clients want us to make, right? How is that not in the phone records? It must have been altered. It must have been doctored. It must have been tampered with. These 911 calls, they have to be wrong. They've edited them. They've made me say things that I didn't actually say in them. A lot of times that can't be proven, right? And he's saying he called for an investigation and they went missing. We'll see throughout the trial if that's true. But clients sometimes want to make these outlandish arguments, and we usually advise against it because it makes it seem like we're grasping at straws, and especially if we say things like he did. I guarantee you're going to find this. I promise. He's making all these promises and guarantees. So if it turns out that the state just says, no, here are the 911 records, here are the T-Mobile records, everything's in here, the reason the call's not in here is because he didn't make that call, that looks really bad when you're screaming like this in your opening statement, right? So that's the difficulty of balancing some decent legal arguments and some bad ones. And he's got all these theories, right? He's got tampering with evidence. He's got witness tampering. He's got destruction of evidence. He's got the state just making up, fabricating evidence, right? He's got all these different theories. Usually we try to pick as defense lawyers one or two of our best and strongest theories that show reasonable doubt or prove innocence, whatever it may be, in a trial. He is kind of going all over the place and probably losing some of the jurors at this point, which is probably because he does not do this professionally. He's not practiced, but he is, I do think he's making some coherent arguments. I'm actually surprised at how well he's doing based on somebody that was incompetent to even stand trial just a couple years ago, and based on some of the statements he made during the killing that made him seem potentially temporarily insane at least. So I was not expecting him to be as coherent as he is, which, it's a pretty low bar, I'll agree, for a pro se defendant. But let's keep listening to what he has to say.
The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original cause. That's what the evidence is going to show. The evidence is going to show I look alone, but I am backed by a mighty God.
Okay, let's pause there, right? Okay to believe that, no problem. But the evidence is definitely not going to show that, number one. And number two, that's something that you don't usually say in an opening statement, and you don't scream it like that, right? I don't think that's a great portrayal to the jury to say things like, the evidence is going to show I may look alone, but I'm backed by a mighty God. That's what he said. To me, that's the type of stuff where if pro se defendants get in charge of their own case, they just say stuff that does not help their case. And it may actually hurt their case. Again, nothing wrong with believing that. I'm not saying I have anything wrong with believing that. I'm just saying not something you should say probably in an opening statement.
The evidence is going to show I love my children. And the evidence is going to prove to you that this whole entire case has been tampered with and fabricated before it's all said and done. I can guarantee you that. Mark my words. The evidence is going to show that they say, I said, come out here, son, and help me kill this bitch. But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa Brothers Gray, or any of her children, Mia Thompson, or Gracie Diggs, or Mr. Gray, heard me say any of those things. In fact, the evidence is going to show that Khalil Brown heard me say, she killed me twice, and then nothing else. The CRA is going to show, for some of you who don't know what that is, that's the criminal report affidavit that the law enforcement lead detective Thomas Sturks is the author of.
So he really is impressive to me. He's taking this seriously. He's obviously prepared. He knows what these acronyms stand for. He's explaining to the jury, realizing they're lay people. So is he. That's what's cool. It's like lawyers, we're explaining things to a jury because they're lay people, they're not lawyers. He's doing that too. Again, He's prepared for this, and he's doing the best, I think, that he can possibly do. Does that change the facts in this case? No. Does it make it any less horrific what he seems to have done or is accused of doing? Absolutely not. We're looking at this simply from a pro se defendant acting as a defense lawyer. It's a sad situation all the way around.
The evidence will show that in that CRA, I told the neighbor, don't come outside. Call 911 now. But you don't hear that on this audio for some reason. But you hear all these other things that I did not say.
So he says, this is where it fails, right? If you've got a losing case and you're trying to make these legal arguments like he is, it fails if you don't have the truth. Because he says, you don't hear this on the audio, all you hear is all this other stuff that I didn't even say. Well, how are we hearing you say it on the audio if you didn't say it? And that's where argument loses against evidence, right? If you actually have recordings and hard evidence, witness statements, your arguments aren't going to beat that. The jury is going to be smart enough to understand that the evidence and the recording of your voice the day that it happened is going to be more important to them now than the arguments you're making in court.
That same CRA will have the statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. The evidence is going to show that Mr. Harmon here says that that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of shot it was, if it was a slug shot or a bird shot, where's the missing pieces of her arm?
I mean, again, that's an argument that a client wants to make when they pick apart every little thing with a fine-tooth comb that a lawyer probably wouldn't make, because the fact that they didn't find missing pieces of her arm, that was the chunks of her arm that were blown off in a gunshot, that doesn't help your case as a defendant, especially when he says stuff like, they say it was a birdshot, it wasn't. Well, how would you know unless you were the one that shot her arm? That's what juries are asking, I would assume. But I'm waiting to hear from you guys in the comments. Is that what you as jurors would think if you heard him say stuff like this? Or would you think that's something that's very probative, meaning proves this case, the fact that they can't find the chunks of her arm? Right? I mean, you tell me.
The evidence is going to show you will not see any missing pieces of her arm in that closet where she was shot. You should see some evidence of shots, but there were several shots added to the wall to make it look like I aimed at her head. That's what the evidence is going to show. Remember, I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show that my son said my dad shot my mom is the correct statement if you want to cite statements, if he even said it. Because I can evidence is going to show you. We are under the most corrupt administration you've ever seen in your life. I guarantee you I wouldn't waste your time. I would have already took a plea deal of some kind if I knew I did something like this. Because most people don't even go to trial when they know they've killed somebody unjustly. The evidence is going to show you who the killers are.
So this is where we start to get into his self-defense defense, right? One of the reasons he's representing himself is because the lawyers told him he wasn't going to have a stand your ground argument. He disagreed. He wanted to put on this evidence of self-defense himself. And we're starting to get into that. And he says stuff like, if I did this, I would have already taken a plea deal. Most people don't go to trial after they've killed someone if it was unnecessary. So he starts to set up the fact that, yeah, maybe he did kill these people. Maybe he did kill his family, but there was a reason for it. It was self-defense. And now we're starting to get into that. And something that is never allowed to be brought up in trial is plea negotiations. And the fact that you didn't take a plea deal cannot be argued as a defendant as a reason that you're innocent, right? That doesn't make any sense. Just like any other case, like if you plead not guilty, that doesn't mean you're innocent. He's trying to use that as an argument to show I'm innocent because I did not take a plea deal. If I was guilty, I would have taken a plea deal. Can't make those kind of arguments, but again, same rules don't apply to a pro se defendant. And still no objection from the prosecutor. So they zoom in on the judge's face, which is important because she makes some facial expressions that you can read into if you want, but it's really hard for a judge and a prosecutor to sit there straight-faced and not get angry and not, even smirk at some of the crazy stuff that pro se defendants say. But that's why they zoom in on her face. And it is important to watch the facial expressions of everybody else because this is totally abnormal for a lawyer to go up against a pro se defendant. It does not happen very often. So that's why I think that's kind of an important clip in this to realize this is not normal for everybody in the courtroom. Everyone's adjusting.
I'm pleading not guilty to the charges of premeditated murder, attempted murder, aggravated child abuse or battery, arson, resisting arrest without violence. And while I'm at that, the evidence is going to show that they tased me for no reason. But they tampered with that video because they didn't want you to know the truth. And it might sound far-fetched, but I guarantee you, we're going to see who the liars are.
And he even says, okay, so this is a little admission on his part. This may sound far-fetched. After he continues to say they tampered with everything, they lied about everything, they set me up, it may seem a little far-fetched. Now, to me, I think that's good for him to at least admit it. Be like, this is far-fetched, but this is actually happening. What he's saying without saying it is this could happen to you. So this is far-fetched, but follow me here. That's basically what he's saying. Follow me with all my theories, right? Tampering with witnesses, tampering with evidence, fabricating evidence, everybody against me, self-defense. Stay with all of his theories of defense here.
We're going to see who the liars are before it's all said and done. Mark my words. Because my family lives were taken. When my daughter was done, this is what the evidence will show. When my daughter was born, it was me who gave the command, the final command to keep her alive when she was on life support. When she was born, 2 pounds, 2 ounces, and couldn't breathe on her own, it was me who fought to keep her alive. But all of a sudden I just want to take her life for no reason.
Very compelling point to me, okay? So he says his daughter was born a preemie, 2 pounds, 2 ounces, couldn't breathe on her own. We talked about how she has special needs, physically and mentally. And he was saying, I fought for her life. I fought for her to be alive. I wanted her to stay alive. I wanted to take her home. I want to take care of her. I've been fighting her for stay alive her whole life. And now all of a sudden I just want to kill her for no reason. Does that make any sense to you? To me, that's a good common sense argument. I don't think the facts are going to line up with what he's saying. And that's something we have to understand is he's making these arguments, he's connecting these points, but I don't think this is at all what the facts are going to show. I don't think this is at all what the evidence is going to show. But I do think it's a good argument for him to say, there is evidence that I've been fighting for my daughter to stay alive her whole life. Why would I kill her now? I think it's compelling, even though I don't think it's what the evidence is going to show.
I'm asserting justifiable homicide because I acted in self-defense and moved to protect myself and my children.
Here we go. Now he's starting to use some legal arguments. It was a justified homicide because I acted in self-defense to protect myself and my children. Except that he killed his daughter is the second part. So I'm not sure how he's going to, deal with that part of the argument. And this is, again, where the house of cards falls apart. You kill your girlfriend and your daughter, it's really hard to come up with arguments as to why you did it. But he's picked one of them. It's not insanity. Instead, it's self-defense. So he's admitting that he killed his girlfriend, but saying it was justified homicide, right? Using legal terms.
From Kenyatta Barron. I'm going to be showing with evidence several reasonable reasons to doubt the state's allegations against me. The evidence will show that the state cannot prove that I premeditatedly killed anyone because I didn't have any time to reflect or plot and plan as if everything happened suddenly and spontaneously.
This is really important stuff, right? I mean, he's reading now, so he's obviously taking some notes as to what you have to prove to not be guilty in two different, this is kind of like competing legal arguments, right? So not only is he saying it's self-defense, right? But he's also saying they can't prove I premeditated this killing. I planned and plotted and had time to reflect, which is the legal arguments we make if we're trying to fight against first-degree murder. A lot of people talk about this in the Derek Chauvin case. Should he be convicted of first-degree murder? Was this a premeditated killing, right? So he's saying this was absolutely not, and they can't prove that it was. And that's something that I think the evidence may actually show, that he didn't plan this all out. It did happen spontaneously. Maybe it was second-degree murder. Maybe it was, he's got to prove a lot more for self-defense, but maybe he does have some evidence to show that this should not be a first-degree premeditated killing. We'll see, but he's using these legal arguments, which to me is so interesting as a pro se defendant with obviously no experience and somebody that was not competent to stand trial just a couple years ago.
I responded out of pure instinct and heat of passion.
A heat of passion killing is literally what we call second-degree murder, not first-degree murder. So he's using these terms, and they're specific and they're purposeful on his part.
Eliminating any kind of premeditated design. And let me just say, the evidence will show that since the state plans to kill me, if they can say that I killed my family unjustly, they plan to premeditatedly kill me. So they cannot say or deny me the right to premeditatedly kill Kenyatta Barron if she killed my children.
So he makes a bunch of arguments that show he's a pro se defendant, not a lawyer. These arguments don't make any sense. No lawyer would ever make these arguments. And one of them is the state premeditatively killed me by having my girlfriend kill my children so that I would kill her, so that I would be... It doesn't make any sense, right? So this is where, again, it just kind of falls flat, and I don't understand where he's going with this, and a lawyer would have taken a red pen and marked this out of their opening statement, because it makes absolutely no sense. So you're about to hear him make another legal decision and legal tactical argument here. He is going to say, this was self-defense, and let me prove it to you. She's got domestic violence in her past. She's on drugs. She's a really bad person. And so you can see this type of person that would come after me and try to kill me, and I had to defend myself and kill her, right? So he's going to disparage and bring up all the old bad things in the victim's past to try to make her seem like the aggressor, okay? And you may hear the first objection 20 minutes into this argument. You may hear the first objection to from the prosecutor.
Evidence will show that Kenyatta Barron had several medications and drugs such as morphine in her system. The evidence will show she had a domestic history and was arrested for domestic violence that same year. She also was born premature, just like Trinivia.
Judge, I'd object at this point.
I'm going to sustain the objection as to that particular argument regarding Ms. Barron being born prematurely. All right? You may continue on, Mr. O'Neal.
The prosecutor stands up and says, Judge, I'm going to object at this point to this argument, right? Finally, 20 minutes in, he's like, I've had enough. This guy's been arguing for 20 minutes. I can't just sit on my hands anymore. Objection. And the judge sustained it like that, which means he wins. It means that this guy's got to stop making these crazy arguments. He can't be screaming. He can't be arguing. It almost seems like the judge was waiting for it. But let's see what this pro se defendant does. It's very interesting to me.
I didn't hear him state the basis of his objection.
What? He said, I didn't hear him state the basis of his objection. This is not a guy that has a legal education. Yet he's making these arguments just like a defense attorney would. Judge, they didn't even state their legal basis for this objection. How can you possibly sustain it? Trying to show the judge is in on this. She's sustaining objections without the state even having to argue what that objection is. That's good lawyering. I'm sorry, but that's good lawyering. I don't know why I'm apologizing for it. That he's right. The state has to state their reason for the objection. And now you're going to hear the judge say, well, I assumed it was because of this and that's why I sustained it. You're not supposed to do that as a judge. You're not supposed to assume what the objections are. You're supposed to protect the record and make a call on why the lawyer who's doing his job is objecting.
I've ruled, Mr. O'Neal, okay?
I understand, but I have to state the basis of my objections, right?
Well, that is correct, and I just assume what the objection is. So go ahead and state it for the record, Mr. Harmon.
Proper argument.
That's sustained.
He says, the judge said, I've ruled, move on, Mr. O'Neal. He says, but judge, I have to state the basis of my objection, don't they? I mean, that's impressive to me. I mean, that's really impressive. And the judge says, well, yes, that's correct, you do. I just assume, fine, state your objection. And the state says improper argument. And she's still going to sustain it. But he is not letting anything get by, this pro se defendant. He is paying attention. He's a smart guy. He is paying attention to everything that happens in this case. And that's going to make it an interesting trial, that he's not just going to be bulldozed or run over by the prosecutor's office, by the judge, by anybody. He's going to try to make sure he has a fair trial.
Threatened to kill me with a knife just a few weeks before the incident, and she was angry about my relationship with my other child's mom, and about the fact that we had to be cordial for our newborn son.
Again, he's giving more evidence that the victim in this case was angry, wanted to kill him, was aggressive, was violent towards him, which leads into his continued argument and his theory of defense, which is that she tried to kill him and he acted in self-defense when he killed his girlfriend. Again, I haven't heard anything about what happened to his daughter, which is what the jury probably wants to know.
And the evidence will show that they have been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car. Me and my son spent the whole day at my mom and dad's house working on the car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day. That's what the evidence will show. Evidence will show that my daughter was prematurely born. She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history of SLD. The evidence will also show that he was present but does not remember accurately or consistently what happened for many reasons.
So as we've mentioned before, his son is supposed to be the key witness for the prosecution. And near the end of his argument, he knows he has to deal with that. He's mentioned it before, and now he's about to discredit his son in a multitude of ways. He's going to talk about his mental disorders. He's going to talk about the fact that he's been coached by people in the department and family members. He's going to talk about how a cop that's involved with this department, involved with this case, has now adopted his son and continued to coach him. He doesn't have a choice. He has to discredit his son as a witness if he is going to win this case. So he's making the correct legal decision and legal maneuver to discredit the strongest witness against him. He has no choice. Whether you think it's right or wrong, legally, it's the step he has to take. If his son is telling the truth, he's going to be guilty. But if he can show that there are reasons why his son may not be telling the truth or may not be remembering it correctly, now he has a chance to discredit that key witness and potentially be found not guilty.
Making him unreliable when it comes to the actual facts. He also has been diagnosed with PTSD, as he should be, because this is a very traumatic thing that he went through. He also was diagnosed with major depression disorder, intermittent confusion, and delirium. The evidence is going to show, the evidence and testimony will show that Ronnie Blair, formerly known as Ronnie O'Neal IV, may have been coached on what to say by family members.
Objection to argument.
And or law enforcement.
Hold on. I will overrule the objection.
Thank you, Your Honor.
Mr. O'Neal, again, jury, this is what both sides believe the evidence is going to show. All right? And again, you will be the ultimate determiner of what the facts are.
So the state objects again, and this time it's overruled, which is interesting. She's saying, I'm going to let him explain what he thinks the evidence is going to show, which is why in law school and on trial team, they tell you to preface everything by the evidence will show. Because if you say the evidence will show, you're saying, Judge, this is just what I think the evidence is going to show. And there's a way to do that, right? So this car crashed into that car. Well, that's argument. Or I could say, the evidence is going to show that this car was traveling and crashed into that car. Maybe not argument, because that's what I think the evidence is going to show. That's why he keeps using that tagline. It's a legal move. It's a legal phrase. It's something we use in real trials as real defense lawyers, and he's using it as a pro se defendant in his own case.
You may proceed, Mr. O'Neal.
Thank you, Your Honor. And these are also actual facts that Mr. Harmon left out when he told you about the report of his former psychologist. When he told you that he was adopted by his family members, which didn't work out as well, and he had to be placed with another family, which is now the Blair family. In that same report, it talked about how he may have been coached by family members. The evidence is going to show that my son was adopted by a detective who formerly worked in this case. Whom he now lives with. And I don't have a problem with that because he needs care. But I do have a problem with Mr. Blair being involved in this case, being called as a witness, being the new father of my son, and now he's being called as a witness.
So a moment of, realizing he's actually the defendant and not just the lawyer, because you can get lost in that sometimes when you hear him make these legal arguments, is he's saying, and now a cop that was formerly on this case has adopted this child, has continued to coach this child, the cop's going to be called as a witness, the child's going to be called as a witness, but he said, I don't have a problem that the cop adopted him because he does need care, obviously, because he's not in your care anymore because of all the stuff that you've done as the defendant. And again, we're so focused on the girlfriend. What about what he did to his daughter? What about what he did to his son? The multiple stab wounds, the burning of 20% of his son's body before his son eventually got away. None of that's being mentioned. But I do think to just the humanity of it that you hear when he says, I don't have a problem with the fact that my son is there. A lot of people are going to comment on the lack of remorse that he has throughout this entire opening statement. And I do think the jury is going to be thinking about that. Let me know if that's something you're thinking about.
When he could possibly have been coached by his new father,
Objection.
who is
Speculation.
law enforcement.
Proper argument.
All right, and again, Mr. O'Neal, I'll rule the objection. Again, this is what Mr. O'Neal is asserting the facts will be. You may proceed.
Thank you, Your Honor. The evidence will show and prove that very vital evidence was definitely tampered with, which was a strategic omission to cover up the facts of this case, making much more of the evidence unreliable. As I know for a fact, it was altered as well. Evidence is going to show that the 911 call of Kenyatta Barron is not compatible with what Khalil Brown saw and heard outside of my home. Evidence is going to show, when it's all said and done, who put those excessive lacerations on Kenyatta Barron's face. I can guarantee you that. In this trial or the next one, I can guarantee you that. Because like I said, I look alone, but I'm backed by a mighty God. And all because they didn't see anything that refutes my self-defense claim and theory. And nor can the state do so beyond their very reasonable doubts that will be revealed. The very reasonable doubts that will be revealed by me. And that's all I have to say.
So throughout the entire opening statement, he brought up his theories of defense. He brought up reasonable doubt. He brought up how high of a burden it was. He brought up the actual charges against them and why they couldn't prove those charges. He brought up self-defense. He brought up tampering with evidence. He brought up inconsistent facts. He brought up evidence that's not going to be shown to you or evidence that you're not going to be able to see as the jury. Those are good arguments. Now the problem is that he focused on just the girlfriend and not the kids. His problem is he showed a total lack of remorse. His problem is he also made some crazy arguments that make no sense and are going to throw the jury off and just be like, this guy doesn't know what he's talking about. He's not making any sense. That's impossible that would happen. So let me know what you think after watching this opening statement, after knowing what the differences are between a pro se defendant and what an actual defense attorney does. What would you do if you were a jury? Would you be more sympathetic to him representing himself or less sympathetic? That's really what I want to know in the comments. I really want to know what you guys think about this as potential jurors on cases like this. We'll continue to follow this trial. We'll continue to comment on it. Let me know if you have any specific questions about this opening statement or anything in this case, and we'll try to do another video in the future. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.